you wrote. I plan to diverge from my prepared text because it occurred to me that you are perhaps the one person who could buy into a very remote decision by the Privy Council, the British Privy Council, I think in 1939, which goes straight into your issue of the tension between jurisdiction and empire, specific jurisdiction, specific legal spaces, and empires as an entire legal space. And it's actually so contemporary because it relates to one of the early leaders of whatever is now our hegemony, the right wing of, say, Israel. One of the very early leaders was a person called Arlie ben Eliezer. No, that's not. He's not featured. Okay. Just in a moment, his father is featured in the case. Now, Ben Eliezer is what was then classified as a terrorist by the British mandate authorities, captured, and like many of his contemporaries, was deported to Eritrea. No, so it must be later than 1939. It could be 42, 43. Now, his father is Arlie ben Eliezer, and his father is Eliezer, now is the name, Zabrowski. Polish name, Zabrowski. Zabrowski appeals first to the courts of Palestine, the High Court of Justice of Palestine, on an habeas corpus, universal, right? Habeas corpus plea to release his son, and his argument is, I think, goes straight into your project. What he says is, all right, so you don't like my son. My son is a criminal, bless him. If you are the hegemony, good for him, good for us. But what is he doing in Eritrea? You have promised the League of Nations and perhaps the world and historians that you are not creating an entire empire. It's not in the 20th century. You are not going back into old colonialism. This is not empire. You are just a mandatory, right? And Palestine was supposed to be a jurisdiction in its own, under king and the League of Nations. So I said, what is my son doing? What a terrorist Palestinian, the Palestinian terrorist, sounds so sweet. The Palestinian terrorist, what is he doing in Eritrea and Djibouti and the Sudan, because they were actually moving them. And the laws go into wonderful eulogy of empire. They say, oh yeah, sure, of course, colonialism is there. We are not an empire. This Palestine, Eritrea is Eritrea. Habeas corpus is, of course, wonderful. There's the universality. They quote cases from Irish revolutionaries. And the undertone is, if we allow the Irish habeas corpus, then of course, Mr. Zabrowski, of course you can have it. But of course, no way, and so they say Eritrea is just a military occupation as a result of Second World War, and Palestine is a mandate. There is no empire. However, and this, I mean, it's not the result has nothing to do with your project, but it's so typical of courts that speak of activism and human rights. Of course, what he actually said, the Lords, he said, well, we believe the High Commissioner when he says that, well, he was poised at just deporting Ben Eliezer, but there was no free ship at the ports. Only one military ship was available. So he put Ben Eliezer on that ship, and this ship happened to go to Eritrea. In Eritrea, the military commander was worried because a terrorist arrived. So he, of course, and so he was now he was a dangerous terrorist in Eritrea, therefore put under custody. Now, but seriously, 5 or so wonderful paragraphs on empire and jurisdiction. So, in the time left, so again, I'll be talking. I feel as if I should have been the subject of your research and not a commentator. Because where I find myself in as a British Council scholar in Oxford, of course, not beyond your era, but extended era. It's the late 70s, but then I get bored with my lecture, and I end up in Kew, in the British Archives, in the British National Archives. And their empire is so obvious. I mean, Palestine, they're at the end of a very, very long journey of bits and pieces of law. Of course, never codification, bits and pieces of. Actually, some of it is just folklore, is legal tales of cases that may have never occurred, of drunken sailors in Jamaica who were flogged or hanged for this or that, and fantastic stories of wives, of husbands who pretend to be, of non-husbands who pretend to be husbands. All this ends up in Palestine, but through what? Starting in Queensland, our Welsh, what is his name? Prime Minister Samuel Griffiths, and then from there to I think Tasmania and West Australia, and then to first north or northern Nigeria, and then Nigeria is federated in 1917. It becomes the Criminal Code of Nigeria, and on every stage, even then, there is some colonial officer who feels the need to take out something and add something, and it's always from another colony. So the colonies add up, and influences add up. And then from there to West Africa, and to Cyprus, and ending in Palestine. And in Palestine, there were continental, I mean, they then assumed it was Ottoman Turkish, but it was actually bits and pieces of the French criminal code translated into first Turkish, then Arabic, then archaic Hebrew, ending up in Palestine, and the local Attorney General, who actually is what Edward Said would have now called him a Orientalist, because he was too much in love with the local folklore, so he ended up, our own Attorney General here in Palestine ended up grafting on the supposedly codified colonial criminal law bits and pieces of French, Turkish folklore. Indian stuff came into the game through the Sudan and Cyprus. Roving attorney generals who were moved from Aden to the Sudan ended up in Cyprus, and felt that it just could not live without bits and pieces of legislation that they loved, like negligent homicide, that has now become part of our law here, and plays havoc on our legal system, for reasons that I won't go into now. It all started from Stephen and Macaulay in India, who felt that they had to discipline the Indians, the local Indians, of course, so that manslaughter that was limited to either intentional or almost intentional homicide was extended in India to negligence, because these two great Englishmen, Macaulay and James Fitzjames Stephen, felt that, well, this is India. I mean, people are negligent here and people die. And they used, again, the ultimate colonial, British colonial venue for it, and that is, well, I think it's Stephen said, well, if two, and he used one of those expressions of Indian servants, if they leave a, what do you call it, a piece of wood that is part of a rail, right? If they leave one by mistake, and then a train full of what? Of course, Brahmins and English colonels is derailed and dies. Well, we cannot condone this. Therefore, negligent homicide, and then it ends up in Palestine. So, right. So, where shall we go? Of course, a very recommendable project. So the colonial perspective in the study of criminal law is definitely essential in the context of former settler colonies. Of course, that's your project. But I say it's even more so and perhaps more challenging and illuminating in the context of dependent native colonies. But what can anyone do? I mean, it's too much, right? But here in Israel, we can offer, I think, an even better option. It's a single better option, and it's just there right in the middle, and it could be used as a laboratory, and we'll do it for nothing. You don't need funding, we'll do it for it. And that is the colonial perspective in a settler colony, where settlers, meaning us, differ from the central power. We are not English. Australians and New Zealanders may feel they are a bit different, but they're in a way part of the European, Northern European, perhaps even British extended nation. Yeah. We are not. And so this idea of, and we are not natives, as Sami Kedar keeps telling us, we are neither natives nor English settlers, we are right there in between. And I think the tale of us receiving British common law for use here now in Israel, the Jewish state is a bit interesting. So, how am I doing on time? 2 minutes. So, I think 2 examples, and it could be interesting. They are gems, I think, because they are hidden within the parts of criminal law that survived reform. The parts that were reformed are interesting for comparison. The parts of our own criminal law that were reformed deliberately, at least presumably on local ethos, all right? It's interesting by way of comparison, but I think even more interesting historically are the parts that survived reform after reform, that just hidden within the criminal law and carry huge burdens of British history, British common law history. So 2 examples, and I'll stop. So, and they're all about offenses.
Okay.
Most criminal lawyers, or of course criminal law theorists, deal with criminal responsibility, general principles. I love offenses. I find fascination in offenses. So why should there be any? Why should there be any breaking in burglary? Burglary is breaking and entering a house of dwelling. So why breaking? Why should entering not be enough? All right? What's so sacred about the membranes, the hymens, if you forgive me, of the house? Well, where houses worth entering were the castles of nobility, in England of course, the actual gate mattered. Everything else was impenetrable. The gate mattered. So tampering with the gate, breaking the gate, was the act of burglary. All right? But they don't anymore. Gates don't matter anymore, even in England. So in modern England said so more than 50 years ago. There's again interesting, there's a permanent reform committee of the criminal law in England, and they do reform, but we don't. So the thing is that gates never mattered here in the desert. I'm being too pictorial now. Tents were never gated even when they housed sheiks. The tents themselves were and still are sacred as homes, dwelling places where family and fortune is supposed to be safe, but their sanctity never hinged on doors or windows. Still, 200 or at least 50 years into the game here in Israel, we still acquit villains who enter without breaking. So, all right. Second one, and this is where I end. So why should theft from employee be twice worse, more than twice worse. Theft from employer, right, or by employee from employer, be twice worse than simple theft, theft from father, friend or stranger. All these are simple thefts, right? The answer lies in the very particular circumstances of very early industrial revolution, when Mother England, poised at world domination by manufacture and trade rather than soldier or priest, poised at world domination by manufacture and trade, had to rely on the artificial loyalty of a hostile working class. The sons and daughters of family-based cottage industries, older cottage industries, could, for a while, only be disciplined, prevented from stealing from their employers, in the shadow of the gallows, while simple thieves were simply deported to Australia. Whatever sense it made in pre-Victorian England, it made none later, even in England. And again, Britain scrapped it more than 50 years ago. The thing is, it never made sense here in the Middle East, and even less in Jewish society, but still, prosecutors still obsessed with this question. Was the stealing from employee or employer in Israel? I think it's interesting. So I think here, folks, both settlers and natives, are not even remotely British, where daily greetings differ from Mother England in more than the number of vowels, as in good day, and beer is not a drink of choice regardless of potency of alcohol. The intersection between cultural law and colonial heritage is perhaps even more interesting. So we offer cooperation and we offer it for free. About a word about the comparison with the French. I think it's fascinating that in a way it was either easier or more difficult for the British than for the French, because for the French codification was so European, so modern, so enlightened. They never really seriously considered importing it into their colonies, and then had difficulties codifying local custom. For the British, it was at the beginning much easier, because they mistakenly assumed that when they codified what they assumed was common law, they codified something that was common. Not in the sense that it was shared, but in the sense that it was simple. It came from bottom up. It is not the product of professors and historians, and it's only later that they had to deal with the tensions. It's only later that they realized that the commonality they were trying to impose the common law on was not their own commonality. It was not English. That is
yeah.
okay. Thank you.